Hello. Well, first of all, let me thank you, the Carol Gaspari University, for allowing me to be here today. Also, thank you to Adam for the invitation and all the kindness he has offered to me. I'm really happy to be here, and of course, thank you also to you for being here and listening to me. A little disclaimer, it's going to be a bit philosophical, a little bit philosophical, so kind of abstract thing. If there is anything you want to ask, I will happy to answer when is the time to do so. Also, because it's quite philosophical, I'm gonna read it straight from the text. So I also apologize myself in advance for such thing, which is not very elegant, but I think for this occasion I will do it. However, at the end, I will give you some ideas that come straight from my mind. This also comes straight from my mind, but it's what I will say at the end is not written, all right? So, okay. Let me also start with a little memory that I have. In a conference held in 2022, the late Professor Dalmacio Negro, which was my mentor and professor to many, really beloved, and he recently passed away, he said something interesting that invited to reflection. And I remember when I was there in that conference, that stuck in my mind. He said, from the 18th century until now, law no longer exists in Europe, only legislation. That's what he said. Law doesn't exist anymore. I knew the meaning of this, but still I wanted to go further. So, of course, with this, Professor Negro was not referring, of course, to the fact that there are no longer rules or laws, or that the state has stopped making them. I think that's pretty obvious. On the contrary, I believe, and he believes, of course, and we have no doubt that there is more regulation than ever. So it's not about not having laws in the sense of their legal form, but about the law in a substantial way, as I will explain. So yes, there is more and more regulation conquering every corner of human existence, extending across all areas of individual and collective experience. So what he meant was, because of this overwhelming legalistic leviathan, and here I'm using the Thomas Hobbes legal monster as an example, we are also witnessing the destruction of the law with capital letters, like I said, in a substantial and ontological sense, as I will try to argue here. It is well known that the most important legacy of the positivist rationalism of legal modernity is the conceptualization, the emergency of a notion of a law that is not longer substantive, but is entirely formal, which means legal. This is something that it is easily detectable in today's legal systems and regulations that are based in positive law. It is true that in the discussion about whether the law should have a political substance or whether it should be built exclusive as an instrument of power, is a debate that now seems obsolete. And I take this dialect, right, from the Schmidt and Kelsen situation during the turbulent times of the Weimar Republic, when the idea of the natural law and the idea of the positive law were confronted. Well, but this conversation, this dialectic is not exhausted. So we can see today that the law has finally shifted towards neutrality, and we know that Carl Schmitt was really against neutrality for a reason. The result is the triumph of a concept of a law that seems to have been freed, liberated from any moral basis that substantiates a true legal ontology. This idea of a substantial ontology will be frequent in my exposition. However, upon further investigation, it seems that this legal appearance that is devoted to its pragmatic utility, established in its forms as a potential, which is typically modern characteristical, right, today still requires, as a center of imputation, to be rooted in the will of the one who prescribes the mandate. So the idea of morality is no longer metaphysical or ontological, but it's political. A univocal will which, under the mode of a formal attribution, constitutes the imputation of the norm, which is an irrevocably moral operation, from Scotus to Occam to Pufendorf to Descartes to Kant. Legal modernity has been prolific in separating the substance of morality from its spiritual dimension and filling it with the useful meaning provided by the will as an efficient cause. If commanding the idea of prescribing a norm is good by default because it is commanded, because morality lies in the legislative discretion of the one who produced the norm, the question of a possible legal ontology is, at the very least, postponed, if not repealed in a favor of an evanescence right, performative right that is subjective. A version of a solipsistic law, subjective again, which depends exclusively on the will. However, this doesn't make any less formalistic or univocal than the old legal political constructions that the early modernity strive in propaganding. We live in the time of equivocism, but at the same time, the way that the legal system is built is still univocal. Hold a second. Yeah, sorry. But this univocal and formal rigidity of the state did not prevent politics, as I said, especially law, from ultimately ending up in the desiderative storm of equivocation. A prologue to today's relativism, and this is something that I want to be focused on, which, as is well known, has its roots in the old nominalist thesis of the autonomy of the individual will that belongs or is independent to God's will, which underlies all the modern legal political issues. So there is a theological shadow in every postmodern construction of the law. What is particularly interesting in this reflection, especially about the most basic and substantial foundation of the law, is to understand the reasons why the traditional concept of the law, which some of us will say that is based on nature and reason, and not just in formal constructions, has given way to a purely voluntaristic configuration of it, a reestablishment of the coordinates of the legal system that understands law as a formal attribution, again, based on potentiality to the detriment of the fact, which means that now everything is possible because the idea of reality is under threat. Everything is discussed, reality include. But for this process to succeed, the very idea of the law had to be terminated, at least in the way that the Western legal tradition defended it for centuries. And here my colleagues have been talking about Aquinas, right? The law has become the receptacle of morality. I say it again, the law has become the receptacle of morality because morality has been reduced to what is potentially attributable given the infinity possibility of attributions by subjective law. This is equivocism, this is relativism, this is postmodernism. But this shouldn't mean that the law is itself moral or that pursues moral ends. It's not about that. The wake of nominalism is long, and if one thing was clear to Occam, is that the purpose of the command is not itself moral nor immoral, but indeterminate. There is no morality in the goal of the law, according to Occam, regarding its goals, not necessarily its primary or remote causes. Precisely because this teleological amorality implies a strong theological morality, I say it again, teleological amorality, no morality in the goals, but a theological morality, morality in the one who prescribes the law, in the will. Modern law is constructed as an extension of the will, which understands itself as moral because it constitutes a mandate, once divine, still theonomous, still theological in its radical origin. The construction is still theological, even though there is no any religious foundation whatsoever. The assertion that the moral autonomy of the law is an update of the potentia absoluta Dei is probably already a cliche. But it serves to demonstrate that the modern legal systems are crammed with theological invocations, like I said, which paradoxically shift in favor of a completely secularized law. Again, we don't live in secular, we don't live in atheist times. I believe we live in very religious time, but a kind of religion that is not spiritual anymore. So yes, everything is justified theologically wise, even though this kind of theology is not transcendent or metaphysical anymore. So again, the phantom of the potentia absoluta Dei is still there. The formula of theoretically is theoretically simple, since the conjuration of a the conjuration of a legislative power that transcends the ordinary order to exchange in exceptional order can only be placed in the altars previously reserved for the divine, now clearly politicized by neutralizing dynamics of the state itself. In other words, yes, the state is working as a god. If the law then becomes an instrument at the service of a personalistic power and is removed from any approximation of a transcendent sense of good, science that is no longer moral in its purpose but exclusively in its origin, it loses its ultimate meaning, finally transmuting into something else, which is no law, which is what I call legislation. So a big difference between law and legislation. Probably the main precedent for the vanishment of the classical notion of the law in favor of the legislative is again found in Hobbes, who had interpreted natural law in rational terms, endowing his Leviathan with an unequivocal legal structure representing, at that time, the divine will. It was a replica. It was supposed to be a replica of the natural order of God, created by God. This paradigmatic example from Hobbes, it is enough to demonstrate that with this baptism began an inevitable process of a loss of the substance of the law. And the result is the abrogation of the ontological dimension itself, which is a recurring theme of the study of the legal modernity, but not less substantial for that, since only after the abrogation of the ontological dimension of the law can we see or can understand his banishment. Once the law has been stripped of its transcendent link via ex natura rei, and a formula used by Scotus, another voluntarist, legislation appears which is simple as a simple technical tool at the service of the ratio status, the cratology, a formal invocation of representation as an extension of the will of the one who prescribes the mandate. Thus, everything is vertible, attributable to being discreetly understood by the will, again, with the place of morality as a translation of God's will under theological efficiency. Again, that shadow of the God's will is still present even though it's not religious. It's just substituted by the state. So I mean that this great scholastic principle, this potentia absoluta Dei, has been hijacked by modernity, by the state and the legal system. However, the constellation of this modern right, transformed into the state legislation, requires a condition of potentiality in the moral form of its attributions. All the attributions formulated are essentially possibilities. Again, there is no factual reality, there's all possibilities, all potential things, which takes on an univocal character after the relevant resolution via scholasticism under the closure of its logical and theological order that effectively takes the form of the state. Again, this transmutation between the theological formulas to the political ones. These intellectual shifts led to the construction of a purely statist legally, understood in terms of positive law, something that has been discussed here. A conceptualization of the legal that is merely performative, like I said, and whose imputable subjects are nothing but more than discrete individualities waiting to be filled by a model attribution that is by an imputation, which is, again, a formal attribution with a condition of possibility. It can be or not, it cannot be. This operation results of a long process of breaking down the previous legal political order that will reach its peaks after Hegel's ontologization of the state and the subsequent triumph of Kelsen's formalism opposed to the natural law. Therefore, in the statistics legality, the subject enjoys the ratione temporis situationis, in which legislative discretion, both individual and the political power, exceptionally transcends the ordinary legal order through an act of personalist will, something that is well known. Again, Carl Schmitt understood very well in his famous NLE with the miracle in the theology, right? Therefore, the idea that the power of the state is autonomous is, in a sense, a myth, although is it self-referential? This is something that I want to also focus later. This brings us back to the dawn of philosophical modernity in its operation to justify the will of the state by replicating natural order, like I said, as a reflection of a political law, which concerns the individual and his condition as a subject, thus doing away with Aristotelian Thomistic hylomorphism that gets deconstructed. For this reason, since the emergence of the state, natural law has been confused with positive law to the extent that legislation constitutes the sole source of legitimacy, the sole source of legitimacy, dictating what is good and wrong. And this is what is relativism, legal relativism, and by extension, moral relativism. For classical legal tradition, natural law is fundamentally law as reflects as a natural reality, which is the objective and universal foundation of the law. So it's not interpreted, perceived through human experience itself. From this experience, we can deduce the specific factor of what is just in action, whose analogical reference is justice in potential as universal value. So justice is something that is also universal. Therefore, the law requires adaptation or ordering in nature as created, which is neither gnosis or hermeneutics. Again, it's not an interpretation, but it's an immutable guiding principle. And this is unthinkable for the statist mentally, which settles the question of law under its relevance to the sovereign will, which is, again, a formally univocal in its construction, but essentially ambiguous in its substance, because it's nominalism, it's equivocist, and directed as subjects subsumed in the totality of the political artifice. Certainly, modern law or legislation, in its practical sense, is not ordered towards the common good, something that has been to be discussed too. If the law is seeking common good or is seeking power. But rather, this is arbitrarily deployed upon uncountable subjects that now constitutes this new moral realm because, as already have been said, the cause of morality lies not in purpose of what is commanded, but in the will of the one who commands. Laws are good because they have been prescribed, not because they seek good. In effect, the subject appears as an indispensable spell for efficiency of the subjective law. The modern subject, whose qualification as a subject is given precisely by this irrevocable subjection to the system, is at the same time the depositary of the law, and therefore the home of morality, and the absolute legislator, being empowered to impose the law at his discretion in the same way that he is the object of discretionary imposition. The purpose of the law, imposed and calculated by and for the subjects, operates exclusively in reference to a type of a private good that is indeterminate in its theological amorality, and it cannot be hierarchized, only politically organized. So, for modernity, again, every law is good, given its prescription, regardless its ultimate purpose for the good. Since the idea of goodness lies exclusively in power to command and the capacity to accept demand. Hence, deep down, all the subjects are virtually equal, except for the holder of the absolute will of the state, which is the eternal dispute with the absolute will of the subjects that compose it. So there is a contradiction here. The absolute will of the subjects against the absolute will of the state. And they coexist at the same time, which is paradoxical. This is a formal construction that will run transversally through modernity to the present day, under the hypertrophied emergency of the legal relativism. This radicalization of the subjective right of early modernity will be taken to these ultimate consequences in postmodernity, close to nihilism, derogatory of nature. Right? This is the fundamental philosophical issue here, nihilism. The subjectivist deconstruction of a law, and this deconstruction of the law has been also mentioned in the previous conference, Suppresses good as the purpose of the law and replaces it with will again, which is both the driving force behind it and the source of the all sovereign legitimacy. Law in modernity is self-referential, which means that justify itself. It doesn't need to seek for extra legal justifications because it has become detached from any adaptation to the idea of justice or fairness. The universal concept of justice that underpins the the objective of, well, the objectivity of the law is dismissed in the transmutation into the subjectivity of the norms, imputable artifacts that operates as technical regulation subsumed in the totality of the subjective law, a law that is fueled by the will that presents this action. The norm then seems to regulate the order imposed by the state, deploying its factual capacity through the exercise of violence. And this is honoring Max Weber's famous state about the monopoly, the legal monopoly of violence. Right? He will say legit monopoly of violence. I will say legal. I don't think it's legit. I see it's legal. The norm is therefore an instrumental provision that formal legalism used to attribute and impose sanctions intended to regulate and modulate human behavior through preserving the structural order of the system, which is presumed to be self-sufficient. The legal system, as a positive legacy of Kelsenian stamp and indebted to Kantian morality and Occam's voluntarism, is fabricated for the imposition of regulations that direct human existence under fictitious neutrality. So as a conclusion, through this brief presentation, I have attempted to resolve the process of eviction or abrogation of the law in favor of a new artificial legal formulas that bring statist law, despite its legalistic, formal, and apparently unambiguous univocism, which is surprisingly closer to an inevitable nihilism, like I said. Legislation unfolds as a mechanism of imputation, which also I have attempted to define here as a formal attribution with condition of possibility. First, it's a mechanism because it's a part of a closet and immanent system. It's not definitely an order, because there is a differentiation between system and order. Since the order tends to project itself into the universal, while the system, which is a self-referential, tends to fold in on itself. Second, it's a formal attribution because the only way out of the system is another configuration programmed by itself. Again, self-reference. Law has performative representation that discretionarily adjudicates imposed realities that are being fabricated by the law, and they are mostly subjective, which operates as false legal ontologies that are completely changeable. Third, as a logical extension of the above, the condition of possibility must necessarily be rooted in the evanescence of the will identified with freedom. The act is postponed and it displays the potential triumphs. That is said, and this is something that has already been emphasized, the will, like morality, plays a dual role as the origin of the prescription and is the final receptacle of the mandate in the subject. In short, we can be inferred from this brief corollary that is the legal modernity has disoriented the compass of the law. Is it an urgent task to revitalize law from its ontological dimension, relocating it in its vein and restoring its substance? If the status legality controls our existence because it presumes itself to be moral by self-determining and self-legitimizing, the law must resist as the last bastion of freedom, which all its strength and dynamism, seeking its legitimacy beyond the ever-changing social and political transformations. Legitimacy, limit to subjective, will always be the enemy of the truth, if there is one that I believe there is. Always the defender of the narrative that mythologizes the political and makes the world sacred. The path to restoring authentical law is arduous but necessary, for it's urgent to reclaim a substantive political theology that restores a sense of order to the individual and his relationship with the common good, which is proper to the natural world and, at least for some of us, which includes me, is a prologue to the divine. And also, to conclude this, in order to summarize what I said, that I understand it was a little bit obscure, I just want to synthesize it with some ideas, maybe easy to understand. With the problem of self-reference of the state, the self-reference of the law, and the problem with the legal relativism. I believe that the problem with the positive law is that criteria of qualification of the goodness of the law is the fact that it actually belong to a legal system. Whether for the natural law, which has been also discussed here, it is the other way around. Because there is an intrinsic goodness in the law, then belongs to the legal system, right? So we can see how in this construction we have very different endings. Again, from the legal system, just because it's legal, then it's good. For the natural law, because it's good, then it's legal. In this changing these words, you change the law, you change the substance of the law. So the morality of the law doesn't come from its construction, shouldn't come from its power to be prescribed, but it should be attached, should be ordered to with a universal conception of what is good. But of course, has to be controversial. It has to be controversial because the idea of morality, of course, is always under discussion. Because even though I personally believe that it is objective, this is something that is not necessarily shared by everyone. So yes, will always be controversy about the idea of morality and about the idea of natural law, and we'll be always discuss this. But that doesn't mean we have to give up about defending the idea of morality and stand for what we believe is the truth. Thank you very much.